In Court on TKO8 Television is brought to you by Campbell Bonding Company. Even the best of us make mistakes, so when trouble finds you, trust Campbell Bonding Company to help you through what can be a confusing and sometimes frightening experience. Jim, Robert, and Cole Campbell work as a family to offer your family understanding and compassion during a very difficult time. Campbell Bonding Company can help get your family back together quickly and confidentially. And in every step of the process, they're there for you. In times of trouble, let their family help your family. Campbell Bonding Company, 870-741-1138.
Court will call 2015-214. This is Boone County case. State of Arkansas versus Richard Baker. Mr. Baker, can you hear me?
Yes, sir.
Very well. This matter is for arraignment on charges of breaking or entering, Class D felony, theft of property, Class D felony, criminal mischief in the first degree, Class A misdemeanor, theft of property, a Class A misdemeanor, resisting arrest, a Class A misdemeanor, and fleeing on foot, a Class C misdemeanor. Public Defender's Office is representing Mr. Baker.
Your Honor, I spoke with Mr. Moon yesterday. Mr. Moon is the attorney of record in at least one other case of Mr. Baker's. Apparently, that representation is not going to go forward, and we anticipate Mr. Baker will, unless he decides to hire private counsel, will become a public defender client. So I'm standing up here just in case.
All right. Mr. Baker, to your knowledge, what is the status of your attorney representation? Okay. That's your understanding?
Yes, sir.
All right. Well, did you hear the statement of the Public Defender's Office?
No, sir.
You couldn't hear what he said?
No.
Okay. Well, apparently he's spoken with Mr. Moon, and there is some question as to whether you have hired Mr. Moon on this case. And so you may need to get some clarification with Mr. Moon on whether he's actually going to represent you in this matter. Mr. Bunch from the Public Defender's Office is standing here today in anticipation, or at least in an abundance of caution, that your case may end up on the Public Defender's docket. So at this time, did you hear me read off the charges against you? This charge? At this time, how do you plead on those charges?
Guilty.
I'm noting a plea of not guilty on the charges. Your case is scheduled at the current time on the Division 4 docket. That's my docket. And are you still able to hear and see me?
Yes, sir.
Okay.
Yes, sir.
Okay. The picture's getting a little blurry on the screen, but as long as you can hear and see me, that's what's important.
Yes, I can.
All right. I'm going to set this matter by scheduling order. This matter will be set down for trial in April of 2016, on the week of April 18th, 2016. I'm going to set it for a pretrial hearing on March 4th of that year, and I'm going to set it for a reappearance on February 5th of that year. And there'll be a written scheduling order that provides for all of those dates. Now, what I'm going to do in addition to that is set this matter I'm going to set this matter down for November 20th as a date to check on the attorney status of your case. Okay? So you need to get that clarified, and then I'm ordering a reappearance on November 20th. So if you were to bond out of jail, you need to be aware that that your case is that you have to be in court on November 20th. Obviously, if you do not bond out of jail, you'll be available to appear before the court on that date. So that's the status of your case. Let me look at the issues of bond in the case. Mr. Brown, do you know where he stands in terms of having a bond?
I'm looking, Your Honor, to see.
I don't see it.
I don't see any.
I don't see in any of the paperwork before me an amount of a bond that's been set in this case.
I don't see one either, Your Honor.
The date of the offense is October 19th, and the file reflects an arrest date is also October 19th.
Sorry, Your Honor, I don't have the 8.1 paperwork.
No, it's not, apparently not in the file. Has a bond been set that you're aware of?
Yes, a $50,000 bond.
$50,000, okay. It's my understanding, just from what was said earlier about Mr. Moon representing him on another case, that he at least has another charge that's pending on the docket. Are there any other matters that, if you were to bond out, where would you live?
At my house on Fort North Chestnut.
You live.
Harrison.
How long have you lived in Harrison?
For 10 years.
Okay. Are you employed, or did you have employment?
I had employment.
Where were you employed?
When I was on unemployment, but I was fixing to work at Tyson's.
Okay.
Don't work for Tyson's.
Okay.
Your Honor, I see that Mr. Baker's been screened for drug court, so apparently there's some concern about some substance abuse issues maybe at this point that are giving rise to some of these behaviors.
Do we know what the other charges were in the other case?
I'm trying to discern that, Your Honor. I apologize. I don't really know offhand.
Is another theft of property charge?
All right.
It's 15-161.
Theft of a motor vehicle and theft of property, perhaps, Your Honor. I think Mr. Bunch informs me.
So that case would be on Judge Putman's docket.
Yes, sir.
Well, do we know what the bond was in that case? Do you have that in anything? Okay.
Your Honor, the state is more concerned about Mr. Baker having some, as long as he has a residence, reports regularly, also conditions for some substance abuse testing, things of that nature, randomly done if he were to be released. I think some of those things are really what we would like to see in place.
Court's going to reduce the bond on Mr. Baker to $10,000. It's going to be conditioned upon, it'll be a cash or professional bond conditioned upon him residing at the address on, you said, North Chestnut?
Yes, sir.
The address on North Chestnut, and becoming or seeking to become gainfully employed, and being subject to I'm going to direct that he'll be subject, as a condition of bond, be subject to drug testing, based on apparently the concerns that led him to be screened for drug court. Those will be the conditions on his bond, and that's where the bond will be set for now. If he has not made bond by November 20th, the bond issue will be subject to review, certainly on that day. All right. Mr. Baker, you may be excused at this time.
Even the best of us make mistakes, so when trouble finds you, trust Campbell Bonding Company to help you through what can be a confusing and sometimes frightening experience. Jim, Robert, and Cole Campbell work as a family to offer your family understanding and compassion during a very difficult time. Campbell Bonding Company can help get your family back together quickly and confidentially. And in every step of the process, they're there for you. In times of trouble, let their family help your family. Campbell Bonding Company, 870-741-1138.
Many things have changed over the years, and so has auto body repair. Even though Ozark Auto Body has been in business for over 30 years, they continue to change with the times. They believe protecting the environment is important and have done so by using environmentally friendly waterborne paint from PPG. This aligns with the technology used by original manufacturers and gives you a lifetime limited warranty. Quality PPG waterborne paint, ASC certified personnel, plus 24-hour towing service. Ozark Auto Body in Harrison, always taking pride in excellence.
Introducing the newest member of the Yamaha off-road family. It thrives in the most remote, rugged terrain. It never steps down from a challenge and travels long distances in search of adventure. The all-new Yamaha Wolverine. It's a whole new animal.
2015-215, State of Arkansas versus Douglas Potter.
Good morning, Your Honor.
Good morning.
I do represent Mr. Potter. He's here for arraignment. We will waive formal arraignment, enter a plea of not guilty at this time, Judge.
Well,
Appreciate it.
the charges that he's here for arraignment on are simultaneous possession of drugs and firearm, Class Y felony, possession of methamphetamine with the purpose to deliver, Class A felony, possession of firearm by a certain person, Class B felony, drug paraphernalia, Class D felony, possession of a Schedule 1 or 2 controlled substance that is not methamphetamine or cocaine with the purpose to deliver, a Class C felony, possession of Schedule 4 or 5 controlled substance with the purpose to deliver, Class D felony, possession of Schedule 6 controlled substance with the purpose to deliver, Class A misdemeanor, drug paraphernalia, Class A misdemeanor, DWI, unclassified misdemeanor, and refusal to submit to a test. All of those are the charges, and at this time, the plea is not guilty.
That's correct, Your Honor.
This matter is on Judge Putman's docket. looking at the wrong year. November 13th. I'm going to order that Mr. Potter will reappear on November 13th to get on Judge Putman's scheduling order.
Do you have an arrest date for Mr. Potter?
This reflects an arrest date of September 22nd, 2015.
Thank you.
Your Honor, if I may, if we could address bond on this case.
Yes, sir.
I believe it's currently set at $75,000 cash and professional at this point. He is a long-time resident of this area. He would be staying with his family, his grandmother specifically. They're both, his mother and grandmother are both in court here today.
Okay.
He would have no issues submitting to regular drug testing as part of a bond. His family has indicated that $15,000 is probably the most that they could afford at this time. But we would certainly accept any reduction in bond that you could make, Your Honor.
What says the state?
Your Honor, I can't honestly tell the court that there's any, I don't see that Mr. Potter's had a history of failing to appear, anything like that. Again, I do agree with sort of the recommendations of the defense. Our main issue would be that it seems that controlled substances are at the heart of this, so we would like to see a curfew, have him have a good, stable residence, employment, and subject to drug testing.
Based on the allegations, the court, rather extensive allegations, together with his previous history, which the court has some familiarity with, courts are going to set bond at $25,000. Bond will be conditioned upon he'll be subject to regular and random drug testing as a condition of his bond. He'll be, the court's going to provide that he'll remain, I won't believe, if I remember right, that Mr. Potter's able to work at this point.
I believe he is on disability, Your Honor.
And so the court's going to provide for house arrest with his family members. He'll be, then that of course will be subject to a curfew from 7 to 7 and he'll be allowed to be away for limited in where he can go at any time in terms of not being around or associating with anyone who is a convicted felon or known to be associated with controlled substances. Those conditions will be on his bond, which, as I say, is set at $25,000.
Thank you, Your Honor. I will go over those conditions with him and make sure.
That'll be the order of the court.
As far as the drug testing, does he need to meet with, I guess, probation as soon as he does bond out if he
I think he's
can?
subject to probation at this point, and that's where the drug testing is going to come into play.
Okay. Thank you, Your Honor.
All right? That'll be the order of the court.
Thank you, Your Honor.
You may be excused, sir. 2015-216, State of Arkansas versus Scott Brandon Johnson. Court will make the appointment of the Public Defender's Office to represent Mr. Johnson. Mr. Johnson's for arraignment on failure to register as a sex offender or report a change of address, a Class C felony, and possession of a firearm by a certain person, a Class D felony. On those charges, how does the defendant now plead?
Wait for formal reading of the charge, Your Honor. Enter a plea of not guilty. Asked to address the issue of bond.
This case is down on the Division 4 docket. Court's going to enter an order that will provide for scheduling order will provide for a reappearance or check status of the case on February 5th of 2016. It'll provide for a pretrial in March 4th of 2016 and trial during the week of April 18th of 2016. Again, that will be done by written scheduling order.
I was just checking.
September 11th.
What is the argument on setting bond?
Your Honor, based upon the charges and what I've read in the affidavit, I believe that a $10,000 cash or professional surety bond would be sufficient to guarantee Mr. Johnson's presence. According to what I've read in the affidavit, law enforcement's assertion is he's lived here for 4 years and has a residence with his girlfriend, and as a result of that, Judge, I think a $10,000 bond would be sufficient.
Your Honor, the state would like to see a little more skin in the game. Simply, for the following reasons, is that the very nature of the underlying charge is that there's been some compliance issues, or there's been some problems with Mr. Johnson meeting his compliance issues, showing up and registering as he's supposed to. Mr. Johnson, while he does reflect that he shares a residence here in Harrison, that would be the problem, because he also shows to be registered in Galena, Missouri. Exactly where Mr. Johnson lives seems to be a little bit up in the air. Additionally, the very neighborhood or area where Mr. Johnson would want to go and reside if he does do that here seems to have, based on the same incident report that Mr. Russo refers to, seems to have a number of neighbors who are concerned about his actions in their neighborhood. So the state would ask for a bond of somewhere in the neighborhood of $30,000, Your Honor, and have that be conditioned on him getting his current registration status sorted out and reporting.
The court's going to set bond at $35,000, and it definitely will be conditioned upon him getting his reporting requirements completely up to date. Court is concerned about the indication that he may have a residence out of state as a part of the reason for the keeping the bond relatively high. Also, again, it speaks to the nature of the charge and the allegations contained in the affidavit in terms of a threat he may represent to the community in which he at least appears to claim he lives, with non-compliance, with alleged non-compliance with the reporting requirements. So that's going to be the basis for setting the bond at that level. And as I say, it would be conditioned upon him getting himself in full compliance with all reporting requirements. Anything further?
No, Your Honor.
All right, you may be excused, Mr. Johnson.
Even the best of us make mistakes, so when trouble finds you, trust Campbell Bonding Company to help you through what can be a confusing and sometimes frightening experience. Jim, Robert, and Cole Campbell work as a family to offer your family understanding and compassion during a very difficult time. Campbell Bonding Company can help get your family back together quickly and confidentially. And in every step of the process, they're there for you. In times of trouble, let their family help your family. Campbell Bonding Company, 870-741-1138.
We moved here in June, 18 years ago, and had not been in the house more than a week, and I popped my hip out of joint. And that was my first experience. And of course, the ER saved my life. I had an aortic aneurysm, and it had leaked all night. As soon as they brought me in here, they knew exactly what it was and exactly what to do.
Tundra TRD Pro powered Team Toyota to victory in the world's most grueling race in Baja. But why should they have all the fun? With available 381 horsepower V8 and the latest technology, it also powers your winning weekends. Qualified buyers get 0% APR for 60 months plus $2,000 special edition cash on a new 2015 special edition Tundra for a total savings over $5,200. Toyota, let's go places.
Books are an important part of your life, and when you go to Books on the Square, you'll find books that will not only be informative, but books that will take you away. Books on the Square now has 2 locations on the south side of the Harrison Square. Books on the Square carries fiction books, books on CD, lots of westerns, and books full of mystery. Books on the Square, too, next to Deb's Frames and Things, has your nonfiction favorites, religious, historical, and even cookbooks. Take a stroll down the south side of the square and visit both Books on the Square.
2015-80, State of Arkansas versus Michael McElroy. Just another charge. Apparently we have another charge involving the same defendant. It's 2015-217-3. Be for arraignment on that one. Let's do the arraignment first. Was the Public Defender's Office is representing Mr. McElroy?
Your Honor, I represent him in the 2015-80. This charge hadn't come through, so he has not applied for it. But based upon my representation of him, the Public Defender's Office, I don't think anything's changed in his application.
Okay.
We'll get the paperwork to the court, but for arraignment purposes, I'll represent him, Your Honor.
On the 2015-217, Mr. McElroy appears on a charge of theft by receiving, Class D felony, leaving the scene of an accident involving personal injury, Class D felony, fleeing in a vehicle, Class D felony, fleeing on foot, a Class C misdemeanor, driving on a suspended license, an unclassified misdemeanor. On those charges, how does he now plead?
Waive formal reading of the charge and or plea of not guilty, Your Honor.
And I'm knowing a plea of not guilty on those charges. They're on Judge Putman's docket.
Your Honor, in light of Mr. McElroy having the 215-80-4 case, and I represent him on that, I'd ask the court to consider transferring this case to this court's docket to allow me to try to put things together.
I'm going to transfer 2015-217 to the Division 4 docket.
Thank you, Your Honor.
All right. And at this time, I will set it by scheduling order for the April 18th, 2016 trial date, the March 4th pretrial date, and the February 5th reappearance, and enter a scheduling order to that effect. Next, I'm going to take up 2015-80, his reappearance here today. Last time that this case was called by this court was on October 9th, and the court noted he did not appear on that date. There's been an outstanding warrant for him, I think, since an earlier date, but if not, at least from October 9th, for his non-appearance in court. Have there been specifically failure to appear charges filed against him in this case?
Judge, I know the court issued an alias. I don't think that...
or are they under consideration, I guess, by the...
It's my understanding they're under consideration, Judge, and I was handed this morning, and I don't know if the court's got a copy of it, but this is a request for DNA sample. It appears that my client's going to have possibly some other potential criminal charges being filed.
I see. Yeah. All right, very, very well. But nothing's been filed at this point. Okay.
No, Your Honor, not on the failure to appear.
All right.
Your Honor, if I may approach.
Yes, sir.
With the motion, I'm just the court has an opportunity to review that.
Okay. I need. Is a hearing requested by the defense?
Judge, I've reviewed all the materials, and I'd be quite honest with you, I don't think I have any kind of legal argument to make based upon the evidence that's been presented in the motion.
The court's going to go ahead on that basis then and grant the motion here. Let's
May I have his arrest date on the 2015-217?
It'll be September 25th.
And is that the same date? What was the date he was picked up on his alias warrant? 2015-80?
I believe that would be yesterday.
That's when the warrant was returned?
Yes, Your Honor. I showed it on November 5th, 2:45 p.m. was when his warrant.
Has he been in custody since?
He's in Washington County.
Oh, in Washington.
He got picked up over in Washington County, and, Your Honor, the prosecutor's office had to do quite a bit of work to get him over here for today. Matter of fact, I think they just were able to pick him up and bring him over in the past 48 hours.
If I'm not mistaken, there's some medical issues that were... Never mind. Shouldn't say things I'm not certain of.
Judge, on his 2015-80 case and reviewing my file, those charges arose out of events that occurred on or about December 22nd, 2014. However, as a result of the investigation and my client being arrested, he wasn't arrested until the end of April. The warrant got issued, and he was arrested actually on April 29th of 2015. And in looking at the court dates that the court set for trial on the 2017 case of 4-8, I think what I'd ask the court to do is on his 2015-80 case is give us new scheduling order dates of the same, the 2-5, 3-4, and 4-8. That still puts us within speedy trial, and it gives us plenty of time if these additional criminal charges come through, of allowing me to work out a disposition on those.
State agrees with that.
All right. We'll set Mr. McElroy then for trial during the week of April 18th, 2016, a pretrial date of March 4th of 2016, and a reappearance date of February 5th, 2016. If there are any, because it gets confusing in these cases where there are multiple arrests and sometimes arrests in different counties, the court would ask if there's any issues going to be raised with regard to speedy trial. The court, those need to be raised at least by February 5th and no later, or as soon as they're known, really. But yes, we need to be looking at that just to make sure we're not overlooking the date. And I've asked counsel for both the prosecutor and for the state and the defense to be looking at that issue. Are there any other issues to take up at this time?
No, Your Honor.
All right. Mr. McElroy, you may be excused at this time. Right now, your next appearance in court is scheduled for February 5th, 2016. You may be excused. 2015-152, State of Arkansas versus Lori Bass.
Your Honor, we're here for reappearance pursuant to the scheduling order. I have received discovery. Your Honor, I'd like to request the court to consider looking at a bond reduction and/or allowing my client to post a signature bond. In reviewing the informations that I have been given in connection with this case, my client was, these events arose back in June 2015, and at that point in time, she was cooperative with law enforcement, and subsequently, between June and August, she was at liberty. She gets picked up on a warrant on August 6th, and her bond has been set at $25,000 cash or pro. She's been sitting in jail since August, Judge, and in light of she's got strong ties to the community, a lot of family members, and in reading the nature of the charges now that I have discovery, I don't see that she's a flight risk or a danger to the community, and based upon her family, residence, and cooperation, I think that a $5,000 signature bond in this case would be sufficient to guarantee her appearance. She can't make any bond whatsoever, Judge.
What says the state?
Your Honor, the state would be all right with the, clearly I'd say the best argument that she can't make it is that she's still there. Obviously, the state would want some of the same conditions I discussed previously with people who have controlled substance issues, like her to have employment, a curfew, etc., just to make sure that she's not placed in a situation that perhaps leads her to make decisions she shouldn't be making.
Where is she residing at this point?
Your Honor, her residence was, and Lori, you can tell me, is your address still 702 North Main, apartment number 6?
That's my mother.
Okay. I'm sorry. That is your...
That's my mother's apartment.
Okay. Is that where you would be living if you were to bond out?
That's her apartment, everything's still fine there.
Okay.
And based upon my discussions with the family judge, it's my understanding that's where she would be.
Review the affidavit. The court's not entirely comfortable with a signature bond, but at this point the court would put in place a $2,500 bond conditioned upon her residing at the address on North Main that was just stated, and that she be subject to random drug testing and seek and obtain employment, as well as a requirement that she observe a curfew from 7 p.m. until 7 a.m. in the morning. And now, if she gets employment that requires her to work during those hours, that will be an exception to the curfew. She'll be allowed to be out during the curfew hours just to go and come from employment. But otherwise, the court, those will be the conditions on the bond.
Thank you, Your Honor. Lori, did you understand that?
Yes, sir.
All right. That will be the order of the court. Yeah.
We're on track with the schedule.
Yeah, their next appearance date is December 4th for pretrial with a January 25th trial date.
Lori, if you make bond, make sure you make contact with our office.
Okay.
You may be excused.
Even the best of us make mistakes, so when trouble finds you, trust Campbell Bonding Company to help you through what can be a confusing and sometimes frightening experience. Jim, Robert, and Cole Campbell work as a family to offer your family understanding and compassion during a very difficult time. Campbell Bonding Company can help get your family back together quickly and confidentially. And in every step of the process, they're there for you. In times of trouble, let their family help your family. Campbell Bonding Company, 870-741-1138.
When you support a locally owned pharmacy, you're contributing to the growth of the community. The dollars you spend stay right here to support our local community. Health Mart pharmacies are locally owned pharmacies. There's one right here. Health Mart pharmacists have a personal commitment to their communities because, just like you, they support their community. Health Mart pharmacies are locally owned and hometown proud. Harrison is a Health Mart town. Sam Alexander Pharmacy on the Square downtown. Health Mart, caring for you and about you.
Attention safe drivers, keep your vehicle safe with new tires from Worley Tire. Stop in and visit with our friendly and knowledgeable staff and get the tires that are best for your car, truck, or SUV. You can even shop with us online at WorleyTire.com. Worley Tire also features batteries, alignments, tire rotation, and repair. Visit us on the web and like us on Facebook for the latest deals and specials that can keep you and your family safe. Worley Tire, 804 East Stevenson in Harrison.
$168, State of Arkansas versus Nicholas Hall.
Your Honor, I'd ask that Mr. Hall be placed on the docket. We are on track with the scheduling order, but recalling the court's attention, we had I'd requested to have him brought before the court earlier to consider a bond reduction, and recalling the court's attention to this, he had been taken to the state hospital. He's currently back, and when we were last in court on October 9th, the court had asked me to try to track down how long it be and where he's at. He's now back at the jail. Your Honor, I've received discovery, and I've had the opportunity to investigate some of my client's claims. Your Honor, it appears that my client borrowed a vehicle from someone, and the person he borrowed it from didn't tell him it was a stolen vehicle. He's not a flight risk. He has residence here in the county, and I'd request that he be allowed to be released on a signature bond, Judge.
Was he released on bond previously?
No, Judge.
Okay.
He's been in jail since his arrest.
His arrest was in July of 2015?
That's correct, Judge. He was actually picked up on, I believe it was actually July 26th.
This case is currently set for February 22nd of 2016 with a pretrial date of pretrial date of January 8th of 2016 and a reappearance date of 12/4 of December 4th, 2015 to check on the status of the case. Essentially, he's here today because at the last appearance in October, there was uncertainty as to that he was in the state hospital or in some medical facility, and the court wanted clarified what his status was. So, what says the defense as to, or what says the state as to the bond issue that's been raised by the defense?
Your Honor, the bonds to the state seems extremely low as it is. Given some of the allegations, I think the state has a little different take on the situation with the car than perhaps the defense does, but it's currently set at $5,000. I'm assuming that's cash professional, which would mean that the only obligation to him would be $500, and we feel like that anything much lower than that may not be enough to guarantee his participation in these proceedings as we need. So the state just feels it's adequate at this point, Your Honor.
Anything further from the defense?
Judge, my client's been incarcerated this whole time. Obviously, if he had the money, he'd be able to bond out. And he did cooperate with law enforcement. He wasn't trying to hide when, in fact, he got picked up when the vehicle ran out of gas right on a major highway. And he told law enforcement who he got the vehicle from, how he got it, the whole 9 yards. And as a result of that, Judge, I think that a signature bond would be sufficient to guarantee his appearance. He's got children. He's got family. I don't see that he's a flight risk or a danger to the community.
Court will set the bond at $2,500. Court's not comfortable with a signature bond in light of kind of the circumstances, including the fact that apparently he was in a hospitalized situation, which I mean, I don't know the circumstances of that. And quite often that indicates some risk to in terms of non-compliance with the law that results in that. And until that's clarified, I certainly won't approve a signature bond, but I will reduce the bond to $2,500, cash or professional.
Thank you, Your Honor.
His next appearance in court right now is ordered for December 4th.
Thank you. Nicholas, your bond was lowered to $2,500, cash or pro.
When you support a locally owned pharmacy, you're contributing to the growth of the community. The dollars you spend stay right here to support our local community. Health Mart pharmacies are locally owned pharmacies. There's one right here. Health Mart pharmacists have a personal commitment to their communities because, just like you, they support their community. Health Mart pharmacies are locally owned and hometown proud. Harrison is a Health Mart town. Sam Alexander Pharmacy on the square downtown. Health Mart, caring for you and about you.
Now what?
Let's go. That way.
Have fun out there on the compact, capable, and entirely new Pioneer 500 from Honda.
Come see us at 824 North Main in Harrison.
You may be excused, sir. 2015-194, State of Arkansas versus Stephen Black.
Your Honor, we were on track with a scheduling order. We'd had them brought back today because we had hoped to have some kind of wrap-up completed. However, in Mr. Carter's absence, we weren't able to accomplish that. I would ask the court to consider putting Mr. Black back on the court's next available court date to see if potentially I could get something wrapped up.
Currently, this case is set by scheduling order for trial in March of 2016. Pretrial is set for February 5th, and his reappearance on the scheduling order is for January 15th, 2016. However, in light of the request of the defense, I'll order him to reappear on November 20th.
Thank you, Your Honor.
All right. You may be excused. We have cases listed on a pretrial list of 2015-18 State of Arkansas versus Gerald Brewer.
Your Honor, Mr. Brewer's case, we're calling the court's attention. We were working on getting records from out of state and also juvenile court records. I can tell the court now we have just received all of those. The mitigation specialist that's working on the case with me was here last week and was able to pick up the juvenile records. We do have some additional work to do in connection with this case, Judge, and that's where we currently stand.
Is it going to be up to the court?
That's what we're anticipating.
Your Honor, I would expect that, based upon the timing of us receiving the information and the additional work that we have to do with the mitigation specialist, we'll probably be in a position to dispose of this case one way or the other. I don't know if we'll have it done by the December 4 date. I'd like to shoot for that for a reappearance and have it rescheduled for a disposition on January 6th, if that's all right with the court.
Are you aware of the pro se filing with regard to statements?
I am, Your Honor, and I've discussed that with my client, and I don't think the court's going to be receiving any more pro se filings.
I didn't know whether that's something we needed to address.
No, I don't think that. I've had the opportunity to review that with my client, and I don't think he's wanting to proceed on his pro se filing. Is that correct, Darrell?
I'm sorry.
We didn't get a response.
Yes, sir.
All right. This case is down for reappearance then on December 4th of 2015. Are we ready to set it for a trial date at this point, or just...
Hey, Judge, if you want to go ahead and set it for a trial date sometime after January 6th, that's fine.
I'm going to set it for the trial during that January 25th, I think we have trials set here in Boone County.
That would work, Judge.
I know we have other cases set, but let's see. And you're indicating possible resolution on he'll reappear on December 4th, and we'll also put it in for January 6th as another reappearance date for a possible plea.
Yes, Your Honor.
All right.
And that time will go to the defendant, Your Honor?
Pardon?
The time will be charged to the defendant?
The period of delay in terms of the trial date will be an excluded period until January 25th.
I think we've been on excluded time up till now at my request, Judge.
All right. So all time will be excluded.
Thank you, sir.
All right. You may be excused, sir.
In Court on TKO8 Television is brought to you by Campbell Bonding Company. Even the best of us make mistakes, so when trouble finds you, trust Campbell Bonding Company to help you through what can be a confusing and sometimes frightening experience. Jim, Robert, and Cole Campbell work as a family to offer your family understanding and compassion during a very difficult time. Campbell Bonding Company can help get your family back together quickly and confidentially. And in every step of the process, they're there for you. In times of trouble, let their family help your family. Campbell Bonding Company, 870-741-1138.